Hello, Das sir.
Emily?
Hello, Das sir. Am I audible to you?
Yeah. Emily, can you hear me?
Still, it's not clear. Your voice is not clear.
Hello, Emily. Emily,
Yes, sir. Yes, sir.
hello,
Sir,
Emily.
I can see. Yes, sir. I can hear you, but there is
Okay,
some
I am
network.
sharing a YouTube link, huh? So kindly share this link.
Sorry, I have seen today's
Yeah,
speaker.
some network issue is there.
To
Check the WhatsApp,
today's
huh?
speaker has sir, Dibesur
Uh,
Das sir.
uh, please,
Our speaker has already joined. I
yeah.
can see.
Yeah. Who's this speaker?
Sir, today's speaker is Ataul Karim sir. Karim sir, am I audible to you? Sir, does sir kindly make our today's speaker co-host?
Karim sir?
Yes, please. Can you hear me?
Yes, sir.
Okay.
Sir, how
Just
are you?
some adjustment, please. Another issue is that I don't know whether I'm connecting from Dhaka now, so there is a problem with the electricity. I hope that everything will be fine.
Okay.
If
You are
I am,
having
if I get disconnected, I will be joining again. Okay.
Yes, sir. Sure, sir. Sir, actually, here is the same problem due to heavy rainfall and all the connectivity is getting very slow.
Hmm. So, am I audible clearly?
Yes, sir. Right now, you are clearly audible to us.
Okay. May I know one thing, that who are the participants? Like, so that I don't know whether they are students or.
Sir, students are also included here, UG, PG students, and all the research scholars, including the research scholars, plus the assistant professor and from different colleges.
Okay. Great.
I think they will be joined shortly by them so that we can start. Let's wait for a few minutes, sir.
Good evening, the participants. We will wait for another few minutes. Because of the heavy rainfall, there is a network issue going on here. So we will start it within few minutes.
Hello, Atul sir, are you online?
Am I audible?
Yes, Sandeepa, you are audible, but the speakers for the today's session I can see over here. He already mentioned that due to network issue, he might get disconnected, but will again resume back. Let's wait. Hello, Karim sir. Hello, Karim sir. Are you online? Maybe he got disconnected. Let's wait.
Am I audible?
Yes, Sandeepa, you are audible. You are clearly audible.
Okay, okay, Dee, can we start the session?
No, actually, wait. Let me check our today's speaker once again. I think today's speaker has got disconnected due to network issue. He will shortly join.
Okay, Dee, I have also seen that. Okay, Dee.
Let's wait for a few minutes more. He already mentioned regarding his network issue.
Network issues. Okay, Dee.
Yeah.
Hello.
Yes, sir. Hello.
Extremely- I was
Hello.
yeah,
Hello.
but-
Yes, sir.
yeah. So when are we starting?
So we are starting soon, sir. Actually, you are disconnected.
I was.
Yes, sir. So we will be starting soon.
Okay, no
Agija?
problem.
Okay.
Just when you are ready.
Yeah.
Hello, am I audible?
Yes, Sandeepa. Carry on.
Good evening and warm greetings to one and all present here. Respected speaker of today's session, Muhammad Atul Karim sir, faculty members, participants, and my dear students. I, on behalf of Gargaon College Fraternity, welcome you all to the fourth session of this week-long online workshop on intellectual property right for the promotion and protection of innovations. Today, for the fourth session, we have Muhammad Atul Karim sir here with us, and he will be delivering his session on the topic COVID-19 Innovation and Access Dilemma. So, before I hand over the session to sir, I would like to briefly introduce him to our participants. Mohammad Karim is a tutor at Munich Intellectual Property Law Center, Munich, Germany. Prior to this position, he worked as a senior lecturer of law at the East West University, Bangladesh, for 5 years. He is also an enrolled advocate at Supreme Court of Bangladesh. His research papers have been published in well-reputed academic journals, which includes Queen Mary Journal of Intellectual Property Law, Journal of Intellectual Property and Practice, and Journal of World Intellectual Property. His areas of interest are intellectual property, innovation, and competition law. He has been awarded with University Grants Commission of Bangladesh Gold Medal for the Best Research Publication in Law. We welcome you, sir, to the session. So, without the further delay, I would like to hand over the session to sir and continue with the session. And I also request all the participants to stay connected with us. And if you have any queries or questions, you can put forward your questions in the chat box.
Thank you so much for your kind and generous introduction. I hope you can hear me.
Yes, sir, we can hear
there
you.
might be some network issues. I'm currently on my vacations in Bangladesh, so we have some problems here with the connectivity. So I apologize for that. Let me just share my screen.
मेरा माइक वो कहाँ है बेटा लीड कहाँ है उसे तूने ली थी लीड
All right. So I think you can see my screen, right?
Yes, sir, we can easily see your slide.
Okay. All right. So in today's talk, what I'm going to do is that I will try to focus some of the current debates and discussion about innovation and access dilemma from the perspective of the intellectual property law. But the thing is that we already know some of these issues. Probably that will be kind of a repeating. But at the same time, the focus of my today's presentation is just to provoke some ideas and thoughts so that we can think about for the further directions. So before making any kind of conclusion, I would be just trying to focus on, instigating some kind of thoughts in our minds. That's the main focus of the presentations today. So when the COVID-19 started, that time we had started with a kind of a big challenge and the problem, but at the same time we understand that always we talk about it this way: when we see some kind of challenges or the problem, at the same time we also see that there is an opportunity or the progress. So in case of the COVID-19 situation, from the perspective of the innovation, we can see that we can see in two ways. One is there is one side that talks about the innovation perspective in terms of the COVID-19 vaccine treatment and all other related issues. At the same time, we also have a other side of the same coin that's related to the access. So in the context of the COVID-19 vaccine, for example, we can think about in this way that the scholars try to explain that the COVID-19, in context of the COVID-19 vaccine, it was developed quickly and in an unprecedented way. One of the reasons was that IP act as an incentive to that. This is one argument. So it is not, IP was not the sole issue here, factor that prompted quick development of the COVID-19 vaccine. Rather, IP was one of the factors. Among the many factors, IP was one of the factors as an incentive to develop the COVID-19 vaccine so much quickly. So this is from the perspective of the innovation. As I am highlighting here, the dilemma between innovation and the access. So here, first point I'm talking about is about the innovation. And the second, we see that from the perspective of the access, there was a question. Factually, we have seen that the vaccines dilemma, we have seen vaccines inequality between the developed country and the developing country. We have also seen in the context of the COVID-19, at the early stage of the COVID-19, about the vaccine nationalism, which has been taken place in many ways, including developed country has purchased most of the vaccines, which they don't need that much. Number of the vaccine they have booked previously, which they don't need that much. So this is kind of thing that has been talked about in a way that is kind of a vaccine nationalism. And in case of the access, there is also another perspective we can think about, is that the scholars try to argue, and many people and policymakers also thought in this way, especially from the perspective of the developing country or the LDC, is that intellectual property created a barrier to access to those vaccines that has been developed by the intellectual property. So we have two scenarios here. In one side, we have a scenario that says that the innovation has been taken place in the context of the COVID-19 vaccine, and innovation taken place. One of the factors was that because of the incentive, that incentive is the intellectual property system. On the other hand, of the same coin, we see even if there was innovation related to the COVID-19 vaccine, there was a problem. There is an issue with the access to those vaccines. And it has been created partially, arguably, created by the intellectual property. So we have two sides of the same coin. On that perspective, keeping this in mind, I would like to go a bit further. For example, this chart, the one I am showing in the screen is, I updated in the last month. So probably it will be like similar to that kind of thing. But if you see this one, here we'll see some of the developing countries that are in the top. For example, Cuba, for example, Chile, for example, in this way, many countries are there. But like for India, I would say India was one of the more, largest vaccine supplier for all over the world. But it was not that much high, for many reasons. But at least this has been the scenario. This has been the scenario for many, because of the contributions of the many factors. Now, what are those factors? I am not talking about that. There are those issues right now. I will be partially touching them probably at the end of my presentation. So we can see there is a perception. What is the perception? The perception is that that there is a problem with there is a progress with the innovation in terms of the COVID-19, and IP has contributed on that aspect in terms of the COVID-19 vaccine. But on the other side of the same coin of the innovation, there is a problem or challenge in terms of the access to those vaccines. And many people argue that IP has created that challenge or barrier. So keeping this in our mind, let us proceed. Now, first of all, I will be trying to focus on innovation perspective. And of course, on the same line of thinking, sometimes I will be also touching on the access perspective. So how does innovation work? So in our innovation model, generally we think about two types of innovation. One is that it's kind of a private innovation model where the private companies, for example, pharmaceutical industry, they put the R&D, try to develop the new drugs or kind of a vaccines. They see like there is a progress of the market. So this is one aspect, but we also see, for example, we also see that other types of innovation model. Here in this context, I would like to only highlight one aspect. That's the Schumpeterian approach to the innovation model. So Joseph Schumpeter, when he was dealing with this capitalism, socialism, and this book, he was trying to focusing on one part. He mentioned one particular term, which was very familiar and popular in intellectual property and innovation field. That is the creative destruction. So one of the arguments was that in a capitalist market, in a free market, the private entity, they compete for the innovation and they compete in the market against each other, and they kind of create, and also they kind of make kind of a destruction. And so the better product and better innovation takes the market, and in this process, the companies, pharmaceutical industry also, they compete among each other, and thereby they create, and they also kind of make a kind of a destruction for other competitors. So by this process of the free competition in the market, we always have the better or innovative products in the market. And then if that is the correct thing, we need to provide them certain kind of exclusivity, and intellectual property can be one of the systems by which we can provide them certain kind of exclusivity. Why? Because we need to incentivize the innovation. So this is what the main concept. Just think about, in this process, this private innovation model is being the main focus. But we also see, in the context of the COVID-19 development, vaccines development, we also see the other kind of innovation model that has been also existed. For example, public funding. We have seen advance purchase. We have seen grant. We have seen prize. We have seen subsidies. We have seen the state has given funding to the pharmaceutical company to develop the vaccine. We have seen there was a kind of advanced payment purchase of the vaccines. Even there was no guarantee whether those vaccines will be effective, whether those vaccines will be effectively against the COVID-19. So now the question then actually came into the debate was that whether can we say that the development of the COVID-19 vaccine as a creative destruction, or we have seen in a different kind of innovation model that has been taken place during the development of the COVID-19 vaccine. I can make one conclusion here is that neither sides are actually correct here. One is that there was some private innovation models we have seen. At the same time, there was some kind of assistance from the state, from the other agencies too. So it was not something that the assistance by the state has been taken place completely replaced the private innovation model. There was no such conclusion. So my conclusion is that it is kind of a mix. Now, on this context of innovation model, there was a debate that in terms of the access issue, there was a debate that whether intellectual property is really helpful in terms of providing the access. Why? Because intellectual property, we kind of having a kind of a faith on the intellectual property system. Why? How? Because we always think if we provide the intellectual property system, it will provide a kind of incentive to innovation, incentive to development. And if we have this in the market, it will ultimately provide kind of an access. Now, the question was that on the context of the COVID-19, we have seen this vaccine inequality, we have seen this problem. Now, on this context, there was a huge debate. An intellectual property system was under stress. There was a huge debate that in terms of what? In terms of, okay, we have the faith that the TRIPS flexibilities are there. For example, compulsory licensing is there. If it is needed, then the state can do that. The state can manufacture the drugs under compulsory licensing. So it will work. But the problem is that on the context of the COVID-19 vaccine, we have seen that the compulsory licensing did not work. So our faith and the reality check was different. So faith was, it works, but the reality check is that, no, it doesn't work. On the second, we see that intellectual property, if we provide intellectual property, the IP holder will provide the licensing. But in the context of the vaccine of the COVID-19, we have seen there was a very much restrictive licensing conditions. So on the faith, we have one thing. On the reality check, we have another fact. On the other aspects, for example, if we provide intellectual property, then it will provide a technology transfer. It will ensure technology transfer. But we have seen that in this context, it was not there. For example, because of the trade secret, because of the data exclusivity, I will explain later on, there was not that much technology transfer, voluntary technology transfer. So in this context, what we can conclude is that on the context of the development of the COVID-19 vaccine, intellectual property system, particularly global intellectual property system, was under attack. So on this context, then there was a big question that what kind of approach should we have? So just for example, I have mentioned here two issues. One is that sector-specific approach versus holistic access approach. So now I'm talking about access. So on the access, we already know that the intellectual property rights, for example, patent, trademark, copyright, or trade secret, this kind of rights are being given certain kind of exclusivity. Now, when to reduce the negative externality in the society, those intellectual properties are also coming with certain kind of exceptions. So exceptions we provide, why? Because to reduce the hardship, to provide the access. But the problem is that these exceptions are very much sector specific. For example, in terms of the TRIPS flexibility, like compulsory licensing, it is only related to the public health, related to the patent. There is, like, for example, on the question of the trade secret, there is no such exceptions, like global exceptions like compulsory licensing. So we have a very specific sector-specific exceptions, like which is covered by the patent, related to the patent. But if the access barrier is created by the trade secret, we don't have an exception. So the TRIPS flexibility, for example, compulsory licensing, which have been given against the patent, if it is there, even if it is there, it may become dysfunctional because it may be barred by the another one, that is the trade secret. Maybe, for example, in case of the data exclusivity, there is no such exceptions. So what is basically important to understand here is that whether we need to have sector-specific exceptions or whether we need to have access paradigm, which is covering the holistic approach. Now, this debate is there. Why? Because in the context of the COVID-19, we have seen sector-specific exceptions are not working because that have been dysfunctionalized by another one. For example, another right, that is the, for example, trade secret, for example, data exclusivity. In terms of the vaccine, those three aspects may be most important aspects, I would say. So what was the debate? Debate was that, okay, we have the intellectual property rights, we have the exceptions, but those exceptions are sector specific. But the problem is that now in the context of the COVID-19 vaccine or treatment, we need an access paradigm, which should be more flexible, more holistic. So we don't have this one. So this is one of the debate of reformation, discussion of the reformation. More so, I would say, in the context of this intellectual property, particularly global intellectual property, that most important aspects is that the reformation of the intellectual property, that whether global intellectual property system has enough resilient system within itself, meaning that whether the system has the resilience to tackle any kind of emergency situation, critical situation like COVID-19. We have seen that in the context of the COVID-19, IP has been criticized a lot. One of the aspects was that intellectual property system, the global intellectual property system, has not been framed in a way that can tackle this type of critical situation. Theoretically, some of the exceptions are there, but practically they are not working. And the result is that the conclusion is that the IP system, as a global IP system, it is not resilient or self-sufficient to address some of this critical situation like COVID-19 pandemic situation that has been created globally, worldwide. So this is the more, I would say this is the bigger debate in terms of the reformation of the intellectual property system. On the context of this debate, access paradigm, innovation paradigm, we already know there was a proposal in the WTO TRIPS Council led by the India and the South Africa about the waiver of intellectual property for a certain period of time, at least during the pandemic time. And this proposal was placed in the TRIPS Council, but we already know that this proposal has attracted so many debates from both in favor and also against of it. But at the same time, we also know that there has been a kind of a deadlock in the TRIPS Council. It has been negotiated, drafted, redrafted again and again. At this point of time, we don't have any concrete result. It's still about this one. So we know the background, we know the proposal, but some of the people are supporting this by saying that this proposal has the merits, and some of the people are opposing it by saying that no, this proposal should not be accepted because it is not good for the future innovation. It is not good for the future precedent, all that. So I have just highlighted that how was the background, how was the debate, and then how was the proposal has been placed into the WTO TRIPS Council. Now, in my aspects, I would only say that why this proposal was good is basically, it is very clear that from the background, we have seen that this has been the background and the barrier has been created. The main argument is that barrier has been created by the intellectual property system. Therefore, for the time being, we should waive IP, which is related to the vaccine and treatment of the COVID-19. This is simply one proposal. Now, on the other side of this proposal, people have started opposing this proposal. One of the key arguments was that it will be a bad precedent for the future innovation. Meaning that we always know that IP always gives kind of a incentive to innovate. And therefore, if we now waive the intellectual property system, maybe in the future, pharmaceutical industry and those corporations will not be interested because they might think that in the future, if there is a similar situation of pandemic, they might think that, okay, this will create a kind of this IP might be waived again. So this is a kind of a bad precedent. So now there was a debate, and we also see that the scholars are arguing both favor and in favor and also against of it. And we also see that, for example, one of the key arguments I'm just highlighting here is that IP waiver should not be accepted because it will be a kind of a bad precedent for the future innovation model. I don't know whether that is like the correct approach or not, but I have some arguments from this perspective. One is that, so we see kind of an incentive. That incentive may be the positive incentive and the negative incentive. All those positive incentive and the negative incentive in an innovation system, we provide. Why we provide? We provide for the economic goal. So in terms of the intellectual property system, the core question, which is, in my opinion, is a basic question, that how should we address future innovation incentive right now? And how should we interpret that innovation incentive? We have seen that the traditional innovation incentive theory always focus on economic aspects of intellectual property. So innovation incentive theory always talks about economic protections of the investment, of the protections of the, returning the investment so that they can, the pharmaceutical industry can invest again in the R&D. So this is a purely from the economic aspects. This is a kind of a interpretation from the economic aspects. In terms of the intellectual property analysis of the IPRS, one of the aspects we always think is that even if we lose the allocative efficiency for the time being, we always target, because we provide kind of exclusivity. By that, we lose, because we create a kind of a negative externality into the society by giving the exclusive right. So people have the kind of a negative externality in the society to have the access. But we always think about for the future gain. What is the future gain? That's the dynamic efficiency. What is that? Is that if we provide this kind of protection, exclusivity now, it will provide overall innovative incentive in the economy. It will create more economic incentive in the economy, and it will create more innovation in the market. It will create more innovative products in the market for the consumer, and they will have the access to more innovative products and services in the market. So therefore, we always, for the future dynamic efficiency, we always lose our allocative efficiency by providing the intellectual property system. This is a kind of a economic analysis of the intellectual property system. But the question I have that's more thought-provoking in my opinion is that in the context of the COVID-19, like this critical situation, whether we always focus on economic incentive or whether we all also interpret the incentive theory from the economic perspective, where the life of the peoples, I would say human life is a matter. Now, should we interpret it from the perspective of the economic sense, or there is a bigger incentive that we think about? There is a bigger perspective, human life perspective that we need to think about. So this is a bigger question in my opinion. Even in my opinion, pharmaceutical industry has the bigger incentive in this regard. How? Because if we remember, in the context of the AIDS, there was a serious criticism against the pharmaceutical industry because there was a criticism that says that they give the priority of the profit, over the human life. So there has been a serious criticism. But now in the COVID-19 context, vaccine context, probably waiving the intellectual property, it is a kind of a recovery of the image of the pharmaceutical industry. So this could be a bigger incentive for the pharmaceutical industry in terms of the branding, in terms of the recovery of their image. So in my opinion, perhaps innovation incentive, future innovation incentive should be interpreted not solely from the perspective of the economic sense, rather perspective of the bigger incentive, in my opinion. There is a scope of interpretation, but it is obviously this is not universally accepted. There can be debate. This can be debated from the both perspective. Now, let me talk about another aspects. So in the context of the IP waiver proposal, a barrier to the access, we always think about that this has been created by the intellectual property. So in the position paper of the Max Planck Institute, their argument was that probably we need to distinguish between the legal versus factual problem. Now, does really, I mean, facts don't matter at all. This may be one question, but actually it is not. So the question is that here is that whether it is a legal problem or it is a factual problem. They argued in this position paper, they argued that the vaccine inequality, shortage of the vaccines are the problem created by shortage of the raw materials, not by the intellectual property. It is created by insufficient production capacity in the developing countries. It is created by complex manufacturing process of the vaccine. It is created by, because the vaccines are not the normal, I mean, generic molecule which can be copied easily. Rather, vaccines are the very complex biological drugs that cannot be copied easily in the developing country, like we have a generic industry like in Bangladesh. So their argument was that the vaccine inequality, the problem we have, is actually created by the factual problem, not by the intellectual property. So therefore, we don't need to waive the intellectual property, or we don't need to go for the solutions in the legal paradigm. Rather, we need to focus on factual solutions. That should be our approach. So this is one aspect. I understand that this aspect has some kind of merits too, just to highlight that nothing should be negated completely blind without examining the same. So this is one aspect. Now, what is the future ahead? Because I want to have a discussions with the audience, so therefore I try to keep my presentation very precise and short. Now let us see what can be the possible solution. The one conclusion is very simple, that we already know that there is no one size solution because of the economic and social conditions of each country. Probably we need multiple approach to the problem, and if we cannot support, like provide or propose one solution for all. Second, my conclusion is that it's a bit frustrating maybe for many of us from the developing country, but my conclusion is that IP waiver is not going to work, and probably they're taking time. It is a kind of a strategy of negotiation. They are taking time in the WTO, and there will be no IP waiver, in my opinion. And in the meantime, the problem will be diverted into different directions. So IP waiver will not be effective. And another one is that it will not probably make a kind of a solutions to the problem. And the second, the most important thing, that's the contribution right now in the debate at the context of this COVID-19 vaccine development and all that. The important debate here we have, or important takeaway, is that we need short time and the long time reform in the intellectual property system, especially global intellectual property system, to provide what? To provide better access paradigm in terms of in the time of in critical time, in the like COVID-19, which is like a global situation, global crisis. This is a very good conclusion and understanding the worldwide that all the policymakers and the scholars that they have. Now, another one is that TRIPS flexibilities did not work. And now the question is that how to promote TRIPS flexibility so that they can tackle future crisis, they can tackle future critical situation like this. So more flexible, more open-ended flexibility might be needed in the TRIPS agreement. So that's another area of discussion right now. This is a good lessons, in my opinion, that has been disclosed by this COVID-19 crisis. Another aspect is that voluntary licenses. We need to think about how global intellectual property system encourage more voluntary licensing, especially or particularly in terms of this critical situation. One of the example can be is that when the funding and the donor agency, they give the fund for this kind of vaccine development and all that, at the time, they should focus on providing some kind of terms and conditions about the more flexible, open voluntary licensing system, so that this corporation, when they have the IP, so that they cannot exercise a very restricted licensing term. So this can be one lesson learned from this crisis situation. And then another is the holistic one, that is beyond intellectual property system, that is the Global Pandemic Framework Treaty. And now, right now, there is a discussion and there is a debate, there is a kind of a negotiation, and the discussion has been going on about that one. And for that purpose, there is a discussion is that how WTO, WHO, and WIPO, they can collaborate each other so that they can create a kind of a better framework about the innovation, at the same time about also the access paradigm in terms of the critical situation. So for that, maybe we have to go beyond intellectual property system, develop kind of a global pandemic framework, where one of the criteria, one of the issues might be is that contributions of the each and every member states all over the world about on their capacity, based on their capacity, and then if they develop certain kind of vaccine for the future, and then if there is a kind of this kind of emergency and pandemic situation, then there will be access provided from those vaccine to those countries. So here we must remember all the countries all over the world, they cannot contribute equally. It may be based on the equity, and after based on the equity, what can be done is that they can provide the vaccine based on the necessity. And mostly that by this global pandemic framework, if there is a vaccine development project, and if the vaccine is developed, mostly its priority should be given to the necessity, meaning that those countries which are developing countries, which are LDCs, they do not have the capacity, they do not have the economic power, they do not have the technology, so they will be given kind of a priority. So this is what I had in my mind. In my whole presentation, what I tried to discuss, or I tried to focus. I tried to focus basically is that on the context of the COVID-19, how innovation worked and how access challenges was there. Now, on the context of the intellectual property system or innovation system, how we should create for the future. And this is a kind of a sharing of my thought. And I understand there are a lot of people, good people are participated in this presentation. I'd be glad to have if you kindly exchange your views, and I'll be glad to have the discussion if there is any opportunity. And I also would like to thank the organizer for giving me this wonderful opportunity to present my thoughts. And I believe that this is an excellent opportunity. And I have seen that there are a lot of participants already there. This is a good sign that we are interested in terms of intellectual property, innovation law, and the critical debate. And I believe this interest is much necessity, very much required from the perspective of the developing country, so that we can put our ideas and our thought into the global intellectual property system. Thank you again. Thank you very much for your kind introduction and also the opportunity. Thank you.
Thank you so much, sir, for your interesting presentation. Sir, we have a few questions for you. Can technology help mitigate the impact of COVID-19 on education? Hello?
What was the question? I missed the question, please.
Yes, sir. Can technology help mitigate the impact of COVID-19 on education?
Yeah, that's a separate question, probably in terms of the intellectual property system. That's separate question of my separate from my discussion about the vaccine and all that. But of course, the issue is that in terms of the education, we have seen that there is a digital divide, right? access to educational materials and all that. But on the in terms of the access paradigm, there is also a kind of perception. We can put it in two ways. One is that COVID-19, the context of the COVID-19, we have seen that technology has been used so much in terms of facilitating the education system, right? We have digitalized, we have been in the digital platform discussing about providing our education and all that. So this is good one. In my opinion, is that one of the learning from the COVID-19 is that it somehow reduces, of course, digital divide to some extent, but at the same time, for example, in terms of this online and digital platform, many students could not access to those digital platform because of the internet, because of the shortage of their data, right? So this might be another issue, like that might create a kind of a more digital divide. So most of the cases, most of the cases, I would say, the institutions were very much sensitive that how the student could be provided better technology, better access. But I believe that yes, in terms of education, better technology, access to technology can remove the digital divide. Yes.
So we have another question. Are there any specific policy measures that are available in international IP law to manage and to mitigate emergencies?
That's the debate. That's the whole core of the debate. Is basically that says that whether in my presentation I also highlighted that whether international intellectual property system has the inbuilt flexibility or inbuilt resilience to tackle this kind of emergency and the negative situation. That's the issue, right? So that's the core debate. And why this core debate is important? This core debate is important not only for this pandemic. This core debate is important for future pandemic. Why? Because probably this will create a kind of a pressure. And we understand, we already know that global intellectual property, for example, perhaps is not self-resilience, does not have that much, resilience within the system so that they can accommodate the situation. So what the now agenda is that what should be done? This is the core agenda. So in my opinion, yes, it is not there, and debate is there, and this debate is healthy one, good one, because it will promote some kind of international reform in near future. And the developing countries are putting the pressure on the developed countries on that aspects. Yeah.
So another question, what is the role of COVID-19 technology access pool launched by WHO in IP-related aspects of innovation? Yes,
this is the good one. The thing, I just mainly think about it this way, was that I told my presentations too that IP gives kind of a monopoly. Now this monopoly will naturally have certain kind of negative externality into the market, into the society, right? The price will be higher, okay, in comparison to non-IP products. Now, to remove this, we have the exceptions to IP. But when these exceptions are not working, then we have some extraordinary measures. So WTO, these measures is also kind of extraordinary measures. That has been launched. Why that has been launched? Of course, that has been launched because of the global criticism that it is not working. It is not working. So they launched it. They launched it to remove certain kind of hardship. Now the problem is that on this technology pool, many corporations did not participate. Right? It's a kind of a voluntary one. Now, if you do not participate, it is not there. Those who participate, it is there. So you can only use those technology pool from those who are participated there, but who are not, you cannot use it. So even that is the case. So that's the different story. So I would say that it was, something is better than nothing. In that aspect, it was better, but it was not that much, you can say that it solved all the problems. No.
So probably the last question. There has been an issue in which Pfizer faces criticism for arguing that intellectual property for its COVID-19 pill is a human right. So can you shed some light on it?
Yes. So this is also a kind of a one you can ask. You can say this. This is, for example, right to health is a kind of a human right. So if you consider that a human rights, then to get the treatment against the COVID-19 through the vaccine or other technology, it also a human rights. And the state is responsible to provide those rights. So this is something, a kind of a commitment of the state under international covenant on the economic, social, and cultural rights. On that perspective, it's a human rights. Now, these human rights, there is a debate that these human rights are being restricted by the intellectual property system. That's patent and trade secrets and all that, right? On that aspect, that this also put the bigger debate. How should you reconcile between the two sets of law? One is that intellectual property law, another is that human rights law. This is the old debate again, and here their solution is two way we can approach it. One way is that you can give the primacy of the one law, meaning you can say human rights will prevail here, or you can say intellectual property rights will prevail here, right? This is one solution, but people say this is not the solution because this will always put the conflict, right? Human rights activists will say human rights will prevail here. The liberal trade protagonist will say that IP will prevail here. This is not the solution. What is the solution? Is that we need to develop intellectual property system in a way that accommodates human rights within itself. All right? If that can be possible, then there will be no conflict. So only this way we can address this, that human rights should be internalized by the intellectual property system. There should not be any conflict within these two systems. So this is the best solution people are talking about. So if we consider that, okay, that right to health has been internalized by the IP system, patent system, then there will not be conflict, and then there will be not be this kind of problem in future. So this is another area of debate. Yeah.
So one more question. What are the sources available for up-to-date information on IP and COVID-19?
Okay, there are a lot of sources here. One is that, as I said, WTO, the WIPO, and WHO, they have three organizations together. They have provided certain kind of platform relating to all the measures relating to the COVID-19. So that can be one source. But in my opinion, is that you can follow TIPS Council meeting to have the information that what is going on there, and you can also look into the WTO and WIPO websites. There is also a lot of information about the IP relationship between the IP and the COVID-19 issues. And in my opinion, there are in the journals, like all the reputed journals, especially IP journals, all those journals, there are in every issues, I see there are some good articles written on the contemporary debate, the dilemma between the innovation and access related to the COVID-19 issues. So this could be also helpful. Yeah.
So one more. Investment of COVID-19 vaccine development has been high and will be higher in future. Given this level of public investment, the suspension of IP rights would not set an example for any future developments of pharmaceutical products, but instead paves the way for the separating out manufacturing process from that for development. What are your view on this?
Yes, I on the first part of this opinion, I agree completely. I agree. This is one side of the arguments, but here also we need to think about that in the critical time, how should we approach the innovation incentive or investment incentive, right? In the IP, how should we interpret that? That's the important point I made in my presentations too. At the same time, just think, maybe is that I'm saying that there would be always private innovation model that would be there, okay, and there would be also private public collaboration model that I have discussed. For example, public funding, for example, price, for example, subsidies, for example, advanced purchase. These are all kind of facilitating the innovation system. So, but probably there can be two approaches. One approach is that in terms of the private innovation model, you will have a very, very strong IP system. Maybe in terms of those innovation model, which has like public and private collaboration, you will have less strict innovation model. You will have better access paradigm over there. If that is the case, then there will be competition between the private and the collaborative innovation model. If that competition is in the market, ultimate beneficiary will be the people, will be the consumer. So in my opinion, in this model, if you allow it, it will have a moderate impact in the future innovation, but it will not have the drastic negative impact in the future innovation model. Yes.
Okay, sir, I think there are no other questions. Thank you, sir. So I do not think we have any more questions, and we almost reached the end of our session for this week-long online workshop on intellectual property right for the promotion and protection of innovations. Now, I would like to request Hare Krishna Mili, sir, Assistant Professor, Department of Mathematics, to deliver the vote of thanks.
Okay, am I audible? Hello?
Yes, sir, you are audible.
Okay, so very good evening to all of you. I'm Hare Krishna Mili. It has been such an honor to be a part of this wonderful session. We have almost come to the end of today's session. So before the end of the session, I would, on behalf of the organizer, like to extend my heartfelt gratitude to the resource person of today's session, Muhammad Atal Karim sir. Thank you, sir, for your precious time and valuable thoughts that you shared to us. We will always be happy to have you in our future events. So thank you once again, sir. I would also like to extend my heartfelt gratitude to the DTIIP, IPR Tesbro University, and IPEZ, and the City Law School, University of London, for collaborating with us. Also, I sincerely thanks to our principal, Dr. Sarvasasi Mohandas, for his continuous support and guidance. And finally, I would like to thank all the faculty members and participants for helping us to make today's session a successful one. So once again, I thank you, all of you. And with this, I announce the end of today's session and hope to meet you all tomorrow for the next session. Till then, stay happy, stay healthy. Thank you, everyone.
Thank you, sir.